Today is Wednesday, December 13th, 2023. Our presenter for today is Frank Ververis to talk to us about disability planning. Frank is the proprietor of a firm in Cedar Rapids that provides planning assistance to people with disabilities and their families. He has been working in this field since 1990. His office has clients from all over the state who contact him for help, including the Brain Injury Alliance of Iowa. I've had the pleasure of working with Frank on a number of my cases. If you would like the new and updated 2024 Social Security Cost of Living Adjustments and Work Incentives reference sheet, please let me know, myself or Frank, with your physical emailing or mailing address, and we will add you to his list. Today, Frank is going to present his workshop presentation on estate and personal life planning for people with disabilities, which will also cover general information about Medicaid, Medicare, and Social Security disability. I will add that Frank is a past board member of the Iowa Brain Injury Council, and that he's also served on the governor's DD Council, Early Childhood Council, Iowa Statewide Independent Living Council, and he is a current board member of Discovery Living. Frank wrote the law in Iowa about special needs trusts for people with disabilities, and he amended another law that impacts people with disabilities. Clearly, he is a very valuable resource, and I know that you'll find today's information very helpful. With that, welcome, Frank.
Thank you very much, Courtney. I appreciate that wonderful, gracious introduction. Now I'm a little worried how I'm going to follow that. I hope I live up to everyone's expectations. All right, so my name is, Courtney mentioned, is Frank Ververis. I'm a proprietor of a firm in Cedar Rapids that has been providing disability services to people who have disabilities since 1990, almost 33 years. And some of the things that I do is I help clients obtain benefits, Social Security disability benefits. I also help clients who I may win a case for that wants to get back into the workforce. I'll help them get into the workforce, and I can monitor their income. I am an approved employment network through Social Security's Ticket to Work program. I work with clients who have countable resources that knocks them off of Medicaid, and I put together strategies what to do with that money in order to gain eligibility again for Medicaid and related services. I also work with a number of people that are in nursing facilities. That's called crisis planning, where example would be a married couple. One spouse goes into the facility. The healthy spouse living at home is worried what's going to happen to their nest egg that they've saved up over the years. So I work with clients in repositioning the assets in order to protect it from complete spend down for Medicaid. Now, the program that I'm going to go through today, Courtney is going to upload it to a website through the Brain Injury, and you're welcome to watch that again. However, rules and guidelines that the state provides for eligibility can change. So I always recommend we have an updated presentation down the road every 1 to 3 years if that's workable with the Brain Injury Association. With that in mind, let me go to some of the slides. And if you're unable to see these slides, please let
You can see them nice and clear.
all right, very good. Let Courtney, I know. Let me see here. For some reason, it's not forwarding.
It's not advancing for you?
There we go. It's
Got it.
advancing.
There
Very
you
good.
go. Very good.
All right. This is going to be an overview of disability planning to provide for your family member who is an individual with a brain injury. A little bit about me outside of what Courtney has already mentioned. My office is not a legal office, a legal firm, a tax agency, an agency of the state of Iowa, or of the federal government. My office is an approved provider, as I mentioned earlier, through the Social Security Ticket to Work program. Furthermore, my office is not owned by or part of a subsidiary of a bank, insurance company, investment, or financial services organization, and we have absolutely no captive relationship with any of these entities. Today's topic: basic planning concepts to ensure your family members' future needs. And then we're going to also talk about the financial aspect, legal planning, safeguarding money for that individual using what I refer to as a life enhancement disability trust, and which conforms to Iowa Code 634A. Now, families typically want, when they're doing planning in advance for a family member who has a disability condition, it could be a brain injury, it could be intellectual disability, it could be MS, it could be cerebral palsy. They want some clarity on the rules. And most programs follow a $2,000 resource limitation in Iowa in order to become eligible for Medicaid and related services. Other programs follow a higher resource limit, but at some point and future date or age, the resource limit can change back to only $2,000. Case in point would be MEPD, MEPD, which allows a person with a disability eligible for Medicaid to have a higher resource limit, currently $12,000, if they are working and earning anywhere from $5 to $10 per month. At age 65, however, that resource level goes back to the $2,000. So it's important, if that person has money that they saved up, we address that so we can preserve that money to make sure that they can be used to enhance their well-being. Another area is eligibility guidelines for services may be different for the county and state programs versus federal benefit programs. Income guidelines for some assistance follows what's called the 300% rule. Others do not. And the 300% rule is nothing more than taking the maximum federal benefit rate for supplemental security income, SSI, multiplying that by 3. And if the person has an income over that amount, they don't qualify for Medicaid. And a case in point would be currently the 300%. The monthly payment for SSI is $914 a month. 300% would be $2742. So it's important for that person to maintain lower income below that amount if they want to maintain eligibility for Medicaid. I'm going to fast forward through this. Before I started doing planning, it was really difficult for parents and families to figure out where to start because they got all this fragmented information. I think it's important to have an experienced planner sort of navigate and coordinate all these different entities for the family so they can make it as smooth as possible. And the family doesn't become overwhelmed in the planning process. Let's start talking about government benefits first. And we'll review the Social Security entitlement, including Medicare and Medicaid. And the reason I want to do this is a lot of the programs that are provided to a person with a disability typically follow the eligibility methodology for Social Security entitlement. So this might be rudimentary to many of you in the audience, but let me go through this anyway so you can kind of see how this all pulls together. The Social Security entitlement was signed into law by President Roosevelt in 1935, and that entitlement, called Social Security Title II, way back then began this trust fund that held sacred money for wage earners, people that work and pay into the system, with the intent that once those individuals reach age 65, there would be an income stream available to help provide money so that they could live a dignified retirement. Well, in 1937, the government made an amendment because back then people would receive their payment in a lump sum. And the first person that got a lump sum payment was Ernest Ackerman. He worked for the Ohio Transit System. He got a 17-cent check, and the government made a deduction from that of 5 cents. So he was supposed to live on 12 cents the rest of his life. Fortunately, that's not the way it works anymore, but that's how it began. Now those benefits are paid monthly. Also at this time, the Social Security entitlement signed into law, the socially acceptable situation was normally, it's not the way it is now, but normally the husband went to work and the mother stayed home to raise the kids. Well, in 1939, Social Security and Congress figured out, we're penalizing the stay-at-home mother because they're doing all these things to raise the children. We need to amend the Social Security Act and provide benefits for her. And what they did then is they created spousal benefits so that the wage earner would create benefits so that the stay-at-home spouse would receive part of that entitlement when they reach age 66 and so on and so forth. The Social Security Act has another component called Medicare, which is Title 18. And this component is a national health care coverage that is typically provided to people that are age 65 and older, or people that have been found to be disabled and are receiving Social Security disability for at least 24 months. The Social Security entitlement was amended in 1956 to provide monthly income called SSDI. Okay, now there is a segment of the population of people that don't have an earnings history. They've been found to be disabled, but because they haven't paid into the system, they're not eligible for Social Security disability benefits under Title II. So in 1972, the government created Supplemental Security Income, which is called Title 16. The abbreviation is SSI. In Iowa, we are what's called a 1634 state. If a person gets any SSI money, they automatically qualify for Medicaid Title 19. The maximum disability payment in 2024 is $3,627 a month. The maximum federal benefit rate in 2024 for a person receiving SSI is $943 per month. The Medicaid component is very comprehensive. It's much more comprehensive than Medicare healthcare coverage. It provides things that Medicare will not provide. It will provide, for instance, placement of a person in a community-based setting through one of the waivers. It will provide prescription drugs that are quite comprehensive. It will provide for an individual to gain many other services that I won't get into. The catch is, in this program, the person in general terms can have no more than $2,000 in benefit, in countable resources, excuse me. If they go over that amount, they lose their benefit package. So if we take a look over here, I don't know if you can see my mouse. The maximum Social Security disability income benefit is $3,627. If a person is receiving that and they want to qualify for Medicaid, they're way over the income threshold to qualify. So planners need to work with the individual and families in order to see if we can reduce that income. And sometimes we would use things such as what's called a Miller's Trust, if you've ever heard of that. That is one strategy that can be used. And there are a number of other things that we can look at in order to protect benefits. And that said, knowing that a person with a disability must follow eligibility guidelines, we can consider options. If we're going to build a legacy for the individual and other family members and leave an inheritance, then we need to look at some things, because if the individual can have no more than $2,000, they receive an inheritance, they're going to lose their benefit package. So some families will come into my office and they'll discuss, well, they think they're not going to leave anything to the person because they don't want to lose benefits. That's kind of unfair, because normally the parents want to leave equal assets to each child, irrespective if they're a person with a disability or not. Being fair, families leave an inheritance directly to the person with the brain injury. What happens? Because they're over 2,000, they lose their benefit. Third option would be parents could leave a sum of money, inheritance, to another sibling or relative, hoping that that person will use it appropriately for the person with the brain injury. That can work. However, it's not necessarily the best option, because that money belongs to the individual that inherits that sum of money, and it belongs to their estate. So if that individual that inherits that money is driving down the street and they rear end somebody and there's a lawsuit, the monies could be spent down in that personal lawsuit settlement. Or worse, if that individual has health problems of their own and they end up going into a nursing facility, monies could be spent down for Medicaid. Another option, an attorney could draft a trust for the individual. Best option would be parents would create a trust in advance for the person with a disability, carefully crafted. I call it a life enhancement disability trust, which is similar to the code that I wrote, Iowa Code 634A, formerly referred to as a special needs trust. but they can be used interchangeably. I recommend when families do planning, they go through 5 separate, distinct steps. Number 1, futures planning. Determining in advance where you want to see goals for your son or daughter's or family member's future. Number 2 is financial planning. And that would be, we're not talking about what stocks or mutual funds to invest in. Basically, it's can we maximize any and every benefit that's out there? And then working backwards, how much money should be used for the individual with the brain injury or the disability in order to provide monies that will appropriately meet their needs. Legal planning, program finalizing, and then maintenance planning. Those are the 5 steps. I'm not going to take a lot of time to go through those, but that's what I recommend parents do, and that's what we try to do when we coordinate with the family in order to make it easy for them to create a continuum for their son or daughter who has disabilities. So I'll briefly talk about number 1. I'll have families that will come into my office and they've got a child that has a disability, and that child may be 25 years old. That family is really that child's constant. The child's gone through special ed classes, has a number of special ed teachers. They've had medical providers stop and look at them. But the true constant that that person has is the family. So I recommend that the family come together, take out a legal pad, and write down these different categories, future living arrangements. And the question would be, you know, if at some point in our life, we're deceased and not in the picture, or if we are ill and have a disability of our own and are unable to provide for our son or daughter or family member with a disability, what are some options we can build in to meet their needs down the road? And we want, if possible, the person with the disability to participate in this exercise, because it is their life that we're talking about, and that's a form of empowerment. We need to advocate for their strengths and let them also participate if they're able to do so. Second area we would categorize would be employment or meaningful day activities, social leisure, medical care, personal needs assistance, transportation needs, religious environment, and then lastly, dignified final arrangement. All of those should be discussed, categorized, approval and understanding from all family members, with input of the person with a disability if capable, and then ultimately, the individual, the family would begin creating what's called a letter of intent, where you express your thoughts and desires for the person with a brain injury in writing, so all family members, future guardians, advocates, and other interested parties know exactly what it is that you want and you agree to. The letter of intent should include information about the person with the brain injury and his or her unique qualities and characteristics, including their likes and dislikes. And if capable, as I mentioned before, they should be part of this discussion. And the reason I say that is a person with a disability may not be able to make complete decisions on their own. So they're somewhat dependent upon others to do that with and for them. In this case, we have a planner working in coordination with the family, working in collaboration with an attorney that's going to do legal work. But out of those 4 different entities, the most important person is the individual, the person that has the disability. That's the goal of this person-centered team approach. How to protect the individual's future by safeguarding money using a third-party life enhancement trust. Let's talk about that. When I wrote the law, Iowa Code 634A, a number of years ago, I did so because at that time, attorneys didn't have a clue what a special needs trust was. And I thought, well, heck, if I can at least draft the bill, introduce it, have it sponsored, and get it approved, then the legal practitioners will have a reference to go to understand that, hey, this is a viable instrument that I can use to provide planning efforts to help enhance the well-being of a person who has a disability and who is receiving Medicaid, SSI, and related services. Now, that's not necessarily going to ensure that the attorney will draft a trust that will pass the scrutiny of the county, state, and federal government, or that the language of the trust will impact appropriately for the person, but at least there is a reference for them to go to understand that this is a viable instrument that can be used. The New Generation Life Enhancement Disability Trust is used to protect government benefits because we want to play off those government benefits if they are rich in service. It will provide supplementary money to step in to make life more meaningful for the individual. The trust provides flexible discretionary language that allows for expenditures that may affect government benefits. I have a client whose son was living in an apartment. The son was receiving SSI. The parents discovered that, the son never left the apartment. They were worried that was he safe? So eventually they purchased a condominium. They were people that had some money. They purchased a condominium for him, and they charged him a monthly rental amount. Well, it came to be that monthly rental amount from his SSI payment was not enough in DHS's eyes to meet the standard rule of, is this the type of payment that would be charged to a non-relative for living in that condominium? And because it wasn't, it was a lower amount. So Social Security, SSI, ended up reducing the monthly payment that the person was receiving by 1/3. It's called a 1/3 reduction. Well, we really didn't care about that because if the person lost $250 to $300 a month of SSI benefits, at least they're still getting benefits. They're still getting their Medicaid services, and they're living in a safe environment. So the trade-off was important, and it enhanced the life of the person, and we made that decision to do that. There should be another slide coming up. Well, moving on, this is a distribution slide. It shows a family that has a smaller estate And the reason I use this slide is I don't want you to think you have to be the Rockefellers or the Kennedys to do estate planning. If you have a small estate, let's address that. And in this case, this hypothetical, the family had 3 children. Each child received fair shares out of the parent's estate at the death. I'm not sure why that's going on. Child A received 70,000, child B received 70,000, child with a disability received 70,000, but what happened? Well, because that individual was a person receiving Medicaid, they lost their benefits, went on private pay, the monies were spent down to the $2,000 resource level, benefits were restored, but unfortunately there was no money remaining for the person to have available to supplement what the government provides. This is the way it can and should look. Same situation. Child A received their fair share, the child B received his or her fair share, and the child with the disability, their money went directly to the Life Enhancement Disability Trust. Monies were used to supplement the needs of the person, and then at the death of the individual, remaining corpus, it's called, goes back to the other 2 children. And normally I recommend families strongly consider, matter of fact, 99.9% of our families will do this, when they're leaving a legacy at the death of the child with the disability, part of that money goes to a nonprofit that has served their child well, and that gives that nonprofit a boost in the arm to help them survive and continue to provide the mission and the vision that they want to provide in the future. The Life Enhancement Disability Trust provides for supplementary needs, but the trustee must be given complete and unfettered discretion to disperse more funds if government benefits are cut in emergencies, or if the trustee determines that current benefits provided by the government are not suitable or do not enhance the beneficiary's right to live and enjoy life to the fullest extent. If that's the possibility, the trustee may then use monies to supplant government benefits. The letter of intent that we discussed out of the 5 steps of planning provides direction to the trustee so he or she can understand what the goals are that you want for the person with the brain injury, and they can therefore use the money to the fullest extent possible. It's a roadmap for the future. Who manages the trust for a person? The trustee does. And I believe family members typically are appropriate successor trustees to manage a trust, because family members typically will have a more sensitive side to them than, let's say, a bank, a financial planner, or a corporate institution. Questions to ask potential trustees. How often, if this is outside of the family, how often do you meet with each individual beneficiary? I would want to know that. And where do you usually meet with him or her? Do you ever meet with the person's service providers, attend habilitation meetings, review and compare MCO coverage options to determine which one is most comprehensive? And you visit with the person's case manager, and if not, why not? And if so, how often? how much special needs trust money do you typically spend for the individual in a year's time? And then when do you typically furnish accounting and disbursement information to the beneficiary or to his or her guardian, advocate, and other people that are part of this program? Let me share this story with you. I get referrals from the University of Iowa Law College. And one of the professors sent this to me. He thought it was interesting, and I thought it was interesting too. I included it in my presentation. In 1997, an attorney by the name of Harvey Platt did an estate plan for a mother of a child with autism. In that plan, he created a special needs trust, can be a life enhancement disability trust as well, for the client's son, and he named himself and JP Morgan Chase as co-trustees. The mother of the child died, and the trust became fully funded with assets from the mother's estate. In 2007, the attorney, Mr. Platt, wanted to be appointed the guardian over the child, so he petitioned the court to start the process. The judge, Kristen Glenn, questioned the attorney and said, you know, why are you an attorney? You're not even a family member. Why do you want to be a guardian of this young individual? And the attorney said, well, I'm already a trustee of the trust that I created for this young man. I think it's only natural that I should be appointed the guardian. And at that time, the trust held $2,700,000 of monies in the trust. Well, the judge said, well, let me see that trust, and I'd like to see what type of expenditure you use to enhance the well-being of this person. And unfortunately, the trustees didn't have any information regarding use of the trust and that they had spent any of the money. So the judge basically reprimanded the attorney and reprimanded JP Morgan Chase. The trust now had grown over a 5-year period to $3,700,000. So obviously JP Morgan Chase made out very well. And over that 5-year duration, the co-trustees eventually spent $3,500 for the young man at the advice of a care manager that they charged a fee of $78,000 against the trust for all of their hard work. So the reason I share this with you, this was again sent by the Iowa Law College to me, is it's important for families to determine who should act as a trustee, and will that person, that entity, actually do the job to provide the utmost reliability and use that money to the utmost extent to enhance our son or daughter's well-being. Very important. What you can do to ensure this is you can use what's called a trust protector, which I'm not going to get into a lot, but basically a trust protector is an overseer of monitoring the efforts and the involvement of a trustee who is managing a trust for a person with a disability, and that person with a disability may not be able to monitor their actions of what they're using the money for completely, so the trust protector steps in to do that. Things the trust protector can do. They can amend the trust provisions to ensure that the person's trust meets guidelines. They can correct scrivener errors. They can review disbursements and accounting, provide trustees with direction, help ensure money is actually used for the person, take over as an interim trustee, or take over as a full trustee if the trustee is not meeting the needs of the individual. And some other things, which I will show you here shortly. The trust protector can do anything the family wants it to do, and they can do that by the letter of intent and by overseeing the Life Enhancement Disability Trust. I have a corporation called Life Planning Administrators, which does trust protection overseeing. I'm not going to get into that at all, but that is a backup. I typically think family members can act as good overseers of the trustees' actions and expenditures. Reasons why we would want to include a trust protector. There could be irreconcilable differences occur between the trustee, beneficiary, or the beneficiary's guardian. Maybe the beneficiary doesn't like the trustee and they want someone else to manage the trust. The trust protector can help with that situation. The trustee finds that, the trust protector finds that the trustee rarely contacts the beneficiary, or the trustee is inattentive to the beneficiary's needs. Trustee doesn't spend money for the person with the brain injury. Never returns phone calls. Or in this one I've always never gets immediate answers. They always have to talk to their legal staff and then call the person back in 2 to 3 days. Well, that's not really workable. If a person needs a winter coat and you've got to check with legal staff to see if that's a viable disbursement, that's not going to work. Corporate trustees, such as a bank, for instance, is sold and the services are transferred to a distant location. This is the quality of life slide showing what the government provides and what the trust can provide for the individual. And on the left, you can see the government provides basic room and board through care and supervision, medical care, some employment opportunities, and basic personal needs through SSI, state supplemental assistance, Medicaid, etc. And this is what the government provides on the right-hand side. Advocate, guardian to look after the person's best interest, additional medical care, dental care, vacations with relatives. I had a client, and this may not sound like a big deal, but it is a big deal, frankly. His ears stuck out. You know, Medicaid wouldn't pay the cost to have that surgically improved because they looked at it to be cosmetic surgery. Well, you know, part of the self-esteem that this person had was slowly going down because there were other kids that were making fun of his ears. Well, those types of expenses can be used to pay for the cost using the money from a carefully crafted trust to provide for those benefits. Gifts on special occasions, self-esteem items, basic care, if there are government cutbacks, all of these can be addressed and monies can be used appropriately to enhance the well-being of the person who has a brain injury or other types of disabilities. That is my overview. I did include a couple of other slides I want to go through, if I may. Let me see. Sometimes I'll have clients that will come into my office and they'll say that they went to a program and some financial advisor was telling them how they could move money around in order to qualify for Medicaid. And that, you have to be very careful because there are guidelines and rules that are actually created by the federal government that the state must comply with and conform to. And if you're caught moving monies around, the state can look back 5 years. They'll bring that money back into the picture and they can go after people that received that money. And so you have to be extremely careful in doing so. The other thing is, there is what's called Medicaid recovery. If a person under age 55 is in a nursing facility and they pass away, their estate assets are open for recovery through the state Medicaid program. If the person is age 55 and older, irrespective if they are in a nursing facility or not, they might be in a waiver home, for instance, or living on their own, but because they're low income, they're receiving Medicaid. At their death, Medicaid recovery will step in and go back after their estate to claim benefits that they had expenses incurred. I won't go through that. Typically, we use Medicaid compliant annuities for a person that went into a nursing facility, and we convert their assets that are being spent down to a monthly payment that is paid typically to the healthy spouse living at home, so we can get more of the money into that estate and protect it from spend down. This is a good one. Life insurance. It should be known that if you have insurance on a child, that child turns age 18, which is the age of majority, life insurance companies typically will revert ownership back to the child, the adult child now. And what happens is the money in the cash value of that policy will go against resource thresholds, and by adding up money that the person has and the cash value of the life insurance policy, the person could end up going over the $2,000 resource level. So it's important for parents, if you have these insurance policies, and you should have them, I'm not saying you shouldn't, that you are the irrevocable owners of the policy so that ownership doesn't revert back to the child. Another thing is, if you are going to apply and try to obtain life insurance policy coverage on your child, make sure that you only use a carrier that has flexible underwriting. Otherwise, a denial will go into the system. It's a code through the Medical Information Bureau out of Chicago. And then if you reapply with another carrier, they see that code and it could detour the eligibility for insurance coverage. So that's important. And then lastly, let me share this with you. I had a lady from Benton County, it was Benton, Iowa, came into my office. She had a son, 29 years old, who was in a car accident, sustained traumatic brain injury. And she was trying to talk with the income maintenance worker about waivers and if we could possibly use a brain injury waiver because she didn't want her son to have to go into a nursing facility. She thought it was inappropriate. He was only 29 years old. Well, the income maintenance worker said, oh, well, your son's not going to qualify for Medicaid anyway because that life insurance policy, that $60,000 life insurance policy, it's got $4,500 of cash value in it. He's over the $2,000 resource level. You need to cash it in, get rid of it, and put it into an irrevocable burial contract. Well, mother came into my office. We discussed this. And she said, what do you think, Frank? And I said, well, I think it stinks. Because first of all, we're taking this big life insurance company off the hook for a proceed payment at your son's death. And the chances of your son getting standard life insurance again could be slim. So here's what we did. I transferred the ownership of the life insurance policy to the mother using an exchange ownership form with the company. Now that's called a transfer for lesser than fair market value. The DHS doesn't like that because you can create penalties for transferring assets in order to qualify for Medicaid. So what I had the mother do is take out the $4,500 and let's give it back to your son. And that's exactly what we did. Now the son still doesn't qualify, does he? Because he's over the $2,000 threshold. So what I had the mother do, I had her take the money, spend a large chunk of it for a computer and programs to engage his brain and mind, and then the remaining money, because he could have up to $2,000, we kept in the savings account at the bank as an emergency fund for him. Now that meant much more, that strategy was a much better option than blowing the money on an irrevocable burial contract, because really the life insurance policy was more than sufficient, the proceeds, to pay for his burial anyway. That is the end of my abbreviated presentation at this point, Courtney.
Okay. That was wonderful. Wonderful, Frank. Thank you so much. We do have a question, one question, if you feel comfortable fielding that before we hop off.
Sure, if I can answer it.
Sure. Okay, so the question for you. Our son was on the intellectual disability waiver when he was younger for a few years. Then didn't have any need for state services until voc rehab. We are working on our estate planning and are wondering about the Medicaid recovery for him. How far back does the state recover? And if we should set up an LEDT for him. He is a college student living on his own and is able to be employed after he graduates.
Okay, very good. Great question, by the way. First of all, if you fund the trust for your son with your assets, then that trust is not going to be recoverable through Medicaid recovery, because it is called a third-party trust. It is not money that he himself received and then placed into a trust. That would be called a self-settled trust. Okay? For his own assets outside of the trust, there could be Medicaid recovery, but typically a person with a disability eligible for Medicaid receiving SSI or Social Security disability, they're not gonna have a lot of estate assets for the recovery program to go after. So it shouldn't be a problem. Did that answer your question? I want to make sure I'm answering that properly for you.
She commented, mom commented, he is not on SSI, SSDI, or on Medicaid.
Okay, then the trust, then you would create it with the idea that maybe he would be down the road. Is that kind of where you're going with this?
Waiting on a comment. What repeat your question again, Frank, just in case. Let's see. Just wondering if the state will recover the Medicaid funds used in his younger years on the waiver.
Oh, no. Only under age 55, okay, so he's a child. If he was in a nursing facility, that's the only rule. Then there's Medicaid recovery. So if your son was never in a nursing facility, they're not going to go back and try to get any type of reimbursement.
Thank you, Frank. And then thank you, big thank you. And then one other one, it looks like popped up. If you can, to clarify the amount of funds that a person with brain injury is allowed to maintain in the bank account if participating in MEPD.
Yes, they can have $12,000 instead of the $2,000 resource level. And then beyond that, if they start going up higher, they can put monies into an ABLE account. We use that in conjunction with eligibility for MEPD. We would establish an iABLE account through the state of Iowa. And with that, they can put up to $16,000, which will be $17,000 per year. And they can shelter that money, and then that is exempt.
Thank you very much. And we have a question about how you hold your appointments. You are located in the Cedar Rapids area, correct?
Yes, I am.
You did it one time. I don't know if you still do. Do you still offer Zoom-based appointments for folks if they do not live in the Cedar Rapids area?
Absolutely, yes.
Wonderful. Anybody else? We have just about a minute here. I did drop your email address, Frank, into the chat box in case folks want to reach out to you about connecting with you, services, anything like that. So I don't see anything else coming up, but Frank, this was a wealth of information, which is the whole reason we reached out to see if you would do this for us. Disability planning comes up all the time with our neuro resource facilitation clients. It's such an important specialized service, and you have been so helpful to speaking for myself on cases that we've shared. So I really appreciate that over the years. With that, again, just thank you for your time and sharing your expertise today, Frank. I just share with everybody the webinar again today was recorded. In case you missed portions or you want to listen to it again or share it with somebody, that should be uploaded to our YouTube page. I would say no later than the end of the day tomorrow. And I guess with that, I will go ahead and conclude today's webinar. Thank you everybody for participating, for being here today. And Frank, thank you again, my friend. I appreciate it.
Thank you, Courtney. It's always a pleasure.
Have a good one, everybody. Thank you.
You too.